Okay, welcome back, everybody. Please be seated. Okay, Mr. Calavo, when you're ready.
Thank you, Your Honor. Mr. Nielsen, I want to go back to where we were prior to the break and just rephrase it a little bit differently for you. When an officer is deciding the level of force to employ, he needs to consider the level of force that is currently being applied by a fellow officer, correct?
Yeah, in the entirety of the event, sure.
So if the LBNR is being applied, you need to consider that as a partner, what you're going to do next, right?
Not just the application of the LVNR, but whether it appears to be effective or not.
So you take the totality of the force that's being applied at the time, in the moment.
No. Not like that.
Okay. So you offered an opinion in direct examination that defendant's Rankin's actions were reasonable,
Correct.
and you prepared a report on this case.
I did,
And the report is pretty lengthy.
if I recall.
All right. And your report doesn't contain any analysis of defendant Rankin's actions during this incident.
I believe that's true.
And there's also no discussion in your report regarding how de-escalation played a part in this case.
Okay.
You agree with that?
Yeah, if that's the question, yes, I do.
And you also cited in your report von Clausewitz,
Yes,
and he's a 1800s military strategist.
correct.
He wrote a book that's called On War,
He did.
and the theories of that include he credited with the developing the concept of total war, where the army attempts to destroy another nation so thoroughly that they can't fight back.
Yeah, that's not the portion that was germane to the analysis, but
That's the author and the strategist that you cited.
he is the author, and he is also a widely cited strategist in conflict. Yeah.
And I believe you talked on or testified back when you were here last time about the different standards for contacts
Yes.
in the Terry stop and arrest. You're also familiarized with social contacts, correct?
I am.
And those are consensual contacts?
Yes.
And when they're consensual contacts, those are done to gather information.
It could be any number of reasons. That could be one.
And in a consensual contact, the civilian has the right to just walk away.
Yes.
And in a consensual contact, if an officer wanted to talk to a civilian, but it's just a consensual social contact, the civilian can, basically say, I don't feel like it, and walk away from the officer.
As with any consensual contact, yes.
There's nothing that would permit the officer to detain him under those circumstances.
On a strictly consensual contact, correct.
Are you familiarized with the term proactive policing?
I am.
And you agree that describes officer-initiated contact in order to look for potential criminal activity?
It could, yeah.
And with that, you're aware that TPD had a proactive policing approach?
I would imagine many urban police departments do have a proactive component, sure.
And would you agree that an individual walking down the sidewalk in a high crime area late at night and officer contacting that individual, just seeing them, would be a form of proactive policing?
That's a pretty broad, it could be, that's a pretty broad set of circumstances.
Okay. And with that broad set of circumstances, you'd agree that the individual could choose to not talk with law enforcement?
Yeah, if it was a consensual contact, correct.
And you were asked some questions, and you, in your report, you included different opinions based on what the video showed and what the video didn't show. You went through several notes about the video in your report.
I did.
And with that, the video doesn't show what Officer Burbank described as Mr. Ellis running at him in a jumping type kick motion, does it?
Which video?
Well, that's a good point. Let's start with the Cowden video.
Yeah, I don't think that there's a portion in the Cowden video that you could characterize that event happening there.
And the first video from McDowell.
The first video from McDowell is like the opening very, very few moments of it. It shows them kind of going to the ground together. And so you can't tell if that's the point at which Officer Burbank was talking about. It could be, but it's hard to tell because it's right at the beginning of the video.
And you recall in your interview back in March of 2023, you said, I don't think so. There's no evidence of that on the video.
If I said that, I don't recall saying that.
Permission to approach, Your Honor.
Proceed.
Anyone who marked as Exhibit 957? Have you seen that before, a transcript of your interview?
I don't think I ever have, actually.
Which take a minute to get familiarized with it and let me know if that is a transcript of your interview.
Yeah, I mean, so far it looks like this is a transcript of the interview we had.
Okay. And on page 114, line 14, you want to get there?
Just lost it.
You can move the binder clip too if that would assist you.
Okay.
You're asking question number 14, or question at line 14. In any of the images that we viewed, did you say jumping type kick that Officer Burbank described in his statement by Mr. Ellis? In your response?
Yeah, that was in response to the images that you showed me. I think there were like a bunch of still captures and such. So I don't think we're talking about the same
You'd
thing.
actually, at that point, you had viewed all of the videos.
Yeah, we did discuss the opening moments of that video where they all kind of collide and go to the ground. Yeah, so I mean I said that the question was in any of the images we viewed, did you see a jumping type kick that Officer Burbank described in his statement about Mr. Ellis? And my reply was I don't think so. So
And you had reviewed all of the video prior to that interview, correct?
yeah, I'd seen the videos many times.
Okay. And you also were asked if you saw Mr. Ellis chasing Officer Burbank into the intersection on any of the videos. You recall that?
I don't, but I'm sure it's in here.
Do you recall that it wasn't contained in the video?
Yeah, I don't believe the video showed Mr. Ellis chasing anybody.
And you'd agree that the video doesn't show Officer Collins getting picked up and tossed by Mr. Ellis?
Yeah, there's a whole host of things I think that happened that aren't contained in the video. That's among them.
There's been prior testimony and based on the video evidence that Defendant Collins had his knee on the back of the head neck area of Mr. Ellis for just under 10 seconds. You don't know anything about that in your report, do you?
I don't think I'd established a timeline for that. No.
And you'd agree that's generally not acceptable police practices to put a knee to the base or to the neck and head area?
It would depend on the circumstances.
You'd agree that there's potential of risk for injury to suspect in doing that?
Yeah, I think anytime you use force, there's a potential risk for injury.
And you testified earlier about Taser training,
Correct.
and the optimal location is split above and below the belt.
Yes, for the spread.
Yeah. And if that doesn't occur, it's primarily pain compliance.
If you have a narrow spread, yes.
And with that, you'd expect screaming from the individual that's getting the Taser deployed in.
Sometimes they just kind of go, "Ugh," but they usually don't say, "Do it again."
And you'd also expect some flailing of the limbs when they're getting tased.
Maybe.
Okay. And you testified earlier that the Taser was not effective when you watched the video, right? Didn't result in NMI?
Correct.
And you're aware in reading both Burbank and Collins' interviews that they said NMI was achieved?
Yeah, I mean, maybe so. I don't think it didn't look like it from what I saw.
Okay. And then when you were interviewed back in March, you viewed a video of recruits that were getting tased, right?
I did.
All that?
Is it the State Patrol one?
It's law enforcement, not WSP. But you reviewed a video of multiple recruits getting tased, some standing and some laying on the ground.
I mean, I've seen. I don't know the specific video that you're talking about. I mean, I know we viewed a video, but I can't remember what specific video it was.
When you viewed that video, it was an accurate depiction of what you would expect individuals to react to being tased, correct?
Yeah, I think, if I recall, I said that they can react a number of ways, and that would be one of them.
Right. Your Honor, at this time, the state would offer into evidence Exhibit 387, which was Exhibit 8, that Mr. Nielsen viewed in his interview, and offer it for illustrative purposes.
All right, objection.
Grounds. Grounds.
Relevant to issues.
It must specifically apply to this circumstance, I don't see the relevance.
I could see this being admissible. I guess it sort of depends on the circumstances that I don't understand. I'm going to excuse the jury while we have a conversation about this. Mr. Nielsen, you should probably go outside while we have this conversation. Okay, I'm not sure what he said exactly about the taser use, although he did indicate, I think at one point about that the LVNR, if it had been effective, it would have been obvious. And I'm not sure if he said the same thing about the taser. And I think he said the first taser use didn't seem to work. I'm not sure he's saying that none of them worked, although that was kind of implied here. But if the point of this is to show that people react differently to being tased, is that what the point is?
Your Honor, the point of it is to both show how people react to getting tased, and there are different reactions to it, but also to put in context Mr. Ellis's reaction to it. I mean, the jurors haven't been in a situation of ever seeing someone tased. They don't know what that looks like, and it explains how some of the movement of the legs, movement of the arms. This is what happens when you get tased. Some of it for pain compliance and some of it on NMI. So that's why it's illustrative and it gives them context, and they can, you know, give as much weight to it as they want. But it's good for them to have a context of how the taser works on the body.
Any further comment from the defense? How long is, by the way, how long is this and who produced this?
It's a minute and 20 seconds, and it's a law enforcement agency. It's
What law enforcement agency?
I believe it was the Bakersfield, and it was,
Sorry, was
I
what?
believe it was training in Bakersfield for law enforcement officers. It's all
Bakersfield,
law-
California?
Yes,
Okay.
but it's all law enforcement recruits, and they're prepared for the taser, and it's going through just to see how. And if the court wants to watch it, it's a minute and 20 seconds.
Any additional comment?
Well, I don't think it's relevant, Your Honor. I think it's a controlled situation, a testing situation. It doesn't necessarily include the context we have here, which a person under the influence, particularly of amphetamine, obviously, as well as the other issues out there. It shows in general what the impact may be, but it doesn't show the situation here, and if it existed in this situation like it depicted in that video. So I don't see the relevance of it at all.
Mr. Usher?
Yeah, Judge, just to elaborate on my objection, I think the court
has identified that in an instance of taser application, there's a variety of reactions, some of which may be consistent or inconsistent with what we have here. But what we know is this is done in a controlled setting where those being tased are not high on methamphetamine, not engaged in a active or assaultive resistance to law enforcement officers. The biggest problem, I think, for the state is this was shown to Mr. Nielsen. He indicated he did not rely upon this for the forming of an opinion, doesn't affect his opinion in any way, and so that it's not relevant to impeach him in any way. This is just an effort to introduce collateral information that the state wants to then argue, oh, look, these guys acted this way, so did Mr. Ellis, without tying it to Mr. Ellis in any way, shape, or form, and so I don't think it's relevant.
You're all right, Johnny.
It's marginal.
Your Honor, he's testified as to how people react to being tased, and this is illustrative of that. And I think it's helpful to the jury. Everything that defense just raised, they can certainly cross-examine on. It's weight, not admissibility.
Well, I'm not sure about that. I guess I'm going to admit it, I think, but the reason, and the reason is, I guess, because it does go marginally to how people react. But Mr. Nielsen conceded that people act differently because it depends on the taser, in the sense of, you know, how far apart is the spread of the taser. I don't know that this was actually said, although maybe one of the other witnesses said there's if the taser barb doesn't actually penetrates clothing but doesn't penetrate the surface of the skin, so you only have one of them, you may not get much of a reaction at all. But again, the taser spread may be wide or narrow, and depending on where it is on the body, it can be more or less effective. So he's conceded that already. Mr. Usher, you're standing up. I assume there's some reason for that.
Judge, I just asked that the court view the video because these officers screaming uncontrollably for a period of time. I don't think it makes the point that the state's trying to make. I think they just want to impact the jury with regard to this. And so I'd ask the court to review it before.
Well, are you saying Mr. Ellis didn't have those same reactions?
I'm saying it's not correlative of what happened to Mr. Ellis. These individuals are in a clinical setting, being tased at optimal spread with optimal impact, whereas that's not the case with Mr. Ellis. He's high on meth, The two tasers are deployed in the chest, they're not even spread far enough apart to have optimal effect on him at the time. So I think it's apples and oranges, as Mrs. Nicola was saying. I don't think it's relevant unless I can say this is consistent with what you're seeing in Mr. Ellis' circumstance. Otherwise, what's the point? They've already testified. There's a variety of reactions to this.
But if there's all kinds of screaming and Mr. Ellis didn't have any screaming, I suppose that meant the taser didn't have as much effect on him. I don't know. Maybe that helps the defense. I don't know. This is to say it's marginal because the effect of the taser is varied, as has been testified by, not just by Mr. Nielsen, but I believe Mr. Ryan did too. But I'm gonna permit it. I'm not sure it tells us anything. The other thing too, I guess I should mention, is that, at least it occurs to me, is that the taser wasn't Mr. Ellis's cause of death in any way. You were gonna say something, Mr. Conrad?
I mean, I just would be interested to see what the video is.
I thought you guys have seen this already.
I've seen one that was played during another use of force experts interview as well. Sorry, Judge, I'll stand up.
Yeah.
And I don't know if it's the same one. If it is, I mean, it's as Mr. Foster described it, which is just these individuals screaming at the top of their lungs, which is clearly designed just to inflame passion and prejudice of the jury. It doesn't have any. I mean, they could play the video of actually Mr. Ellis and say, are these noises consistent with the individual being tased? But instead, they play videos of cadets in California getting tased at high volume, screaming at the top of their lungs. I mean, the judge, you really should look at it.
All right, you've convinced me. I'll watch it. Go ahead and play it.
Mr. Conrad, are you doing Mr. Nielsen or is?
Go ahead and play it.
Can you play it, please?
It's important for the cadets to experience the taser itself because they need to understand not just what they're doing to other people, but also what it can mean if they ever accidentally become exposed to that. It is painful. There's no doubt about that. There's muscle convulsions. The muscles in between the two probes are convulsing and tightening up. And it's going back and forth very fast. The 5 seconds seems like a long time. It's actually harder to watch.
This is by the Bakersfield Californian. Is that like a newspaper or something?
Bakersfield?
Yeah, when the clip opened up, it said Bakersfield Californian. Right, open it, play the beginning of it again, you'll see what I'm talking about. The Bakersfield Californian,
Yeah,
underneath that. What's that?
Bakersfield, California.
Yep.
California, I think.
Is it IAN at the bottom there? Huh? It's not, and besides, it's the Bakersfield, California, or Californian, right?
We could certainly start it after the first slide.
Well, I'm just wondering, who's this produced by? This just shows a bunch of people yelling, being held up by other officers. I guess the thing that actually troubles me, though, I suppose to some extent about this is, it shows officers sort of finding this funny.
Well, Your Honor, part of that is they're prepared for it and they're ready for it and they're in a different setting.
No, I imagine it's something to do with the fact they realize nobody's likely to die here, but they clearly are making some very uncontrolled sort of noises. But it shows the other officers around them, like, this is funny.
I mean, that's the purpose the state is offering it for, is illustrative of how people react when they're getting tased, not for the individuals that are surrounding them. And particularly the recruit that was on the ground, and you could see how he reacts with the flailing and legs flailing, and in a very similar position as Mr. Ellis at the time of being tased.
Googled Bakersfield.com. That is a newspaper in Bakersfield, California, but it's not a police agency.
So it's not prepared by law enforcement, it's
Well,
prepared by
was-
someone.
It was done by law enforcement that's on it. It was distributed through a different site.
I don't know. No one has tried to claim this isn't painful and debilitating. If anything, everybody said it does exactly that. It's the reason they use tasers. So it's, as I indicated before, it's of marginal relevance. It bothers me that there's people sort of finding this funny. I think that's disturbing. And that might be, and these are obviously law enforcement folks. I'll find under 403 that, well, there may be relevance, although marginal, it's more substantially prejudicial than probative. So we won't go there.
No, we're ready to have him back.
Got the drink. Okay, welcome back. Please be seated. Next question.
Mr. Nelson, you testified earlier that people can react in a variety of different ways to being tased, correct?
Correct.
And that includes the flailing of their limbs
Yeah, depending on the application, it could.
and involuntary movement of their limbs during the tasing application.
Yeah, it could.
And a painful response verbally.
Yeah, it could.
And you testified earlier about the LVNR that Defendant Collins applied during this incident. And the purpose of an
I
LVNR,
object to the characterization of the testimony.
Well, he was asked about an LVNR in the,
I'm talking about
Sure.
it being applied. This is the characterization.
well, overruled. You may answer, you may continue your question.
thank you. You would agree that the purpose of an LVNR application is to render the suspect unconscious.
Yes.
And depending on how it's applied, whether it be an actual LVNR or if it gets moved in that application, it restricts either the oxygen or the blood flow to the brain.
Can you repeat that?
And an LVNR is applied at times when the individual who it's being applied to can be moving around, right?
They often are, yes.
And when they're moving around, sometimes you don't get the application right where you want it on the carotid, correct?
Yeah, I mean, that could happen, yeah.
But the result of it is you're going to, if applied correctly, you're going to impact the flow of the blood or the oxygen to the brain, correct?
If it's applied incorrectly, you said?
Correctly. If it's applied correctly.
If it's applied correctly, then you're going to impact the flow of blood and oxygen to the brain, is that what you said?
First blood to the brain.
Correct. If it's applied correctly, yes, it will constrict the blood flow to the brain, which renders the person unconscious. Correct.
And if it's applied to an individual who is moving about, it can get turned into basically a chokehold, but it's done with the arm, which would then impact the oxygen that goes to the brain.
Yeah, it could, but that's typically, when you're doing it, you can typically sense them, you adjust with it, you can typically avoid that, is the person applying it. Because you know, like, do you know the technique wouldn't necessarily indicate where the throat would fall between the bicep and the forearm. So you wouldn't go like forearm on the neck, that typically wouldn't happen.
And you've never been certified in the LVNR?
No, I haven't, no.
And you've never had the LVNR applied to you to the point of going unconscious?
Correct, not to the point of going unconscious,
And
correct.
you've never applied it, the LVNR, to someone else to the point of putting them in an unconscious state?
Yeah, I've never done it to anyone and rendered them unconscious.
And in viewing the Cowden video, where we see the LVNR and Defendant Collins' arm up around the neck of Mr. Ellis, you recall that?
Yes.
And in viewing that video, you never see Mr. Ellis striking, like punching behind him at Defendant Collins, do you?
No, I didn't see Mr. Ellis punching Officer Collins at that time.
And you never see Mr. Ellis elbowing behind him at Defendant Collins, do you?
I didn't note that, I don't think so.
And you don't see Mr. Ellis reaching for a weapon during that time, do you?
I don't believe so.
You testified earlier that you didn't include any analysis of Mr. Rankin's actions, specific analysis of his actions in your report, and that includes that you didn't include any analysis of the force that Defendant Rankin used on Mr. Ellis when he was in the 4-point restraint.
Correct.
And prior to writing, permission to approach him. Prior to authoring your report, you weren't aware of the length of the hobble that was used in this case, were you?
Prior to writing my report, I don't know if I was or not. There's not a huge variance.
And the standard hobble length would be about 42 inches.
Yeah, that sounds about right.
And in this case, Exhibit 100 has previously been admitted and has been identified as the hobble that was used on Mr. Ellis by DNA. It's about 29 inches.
Is there a question?
That wouldn't be consistent with the standard length of a hobble for law enforcement.
What are you asking me?
29 inches, you just testified that 42 is consistent with the standard length. 29 inches wouldn't be consistent with the standard length for a hobble.
Well, I don't know that's 29 inches, and B, I don't know how you're holding it now. I mean, you can manipulate the length of it just by how you're adjusting it.
The longest length is 29 inches, based on testimony and measurement.
Okay, I don't know that, but
And in your experience in training, have you ever heard of the brand Ankra?
no, I haven't. Not all hobbles have that cam, like that.
This end?
Correct. Yeah.
And are you familiar with the brand Ankra being a cargo strap brand?
I'm not. I also know there's a variety of implements that are used to hobble too. So, I mean, that could be. I don't know if there's a company that makes specific items for that application. The ones we have that I've seen don't look like that one.
Excuse me, madam. Court reporter. You've heard the term in your custody, in your care for law enforcement?
I'm familiar with that principle.
And you would agree that police officers are trained that when they take a person into custody, they're in charge of their care?
Yeah, they have a responsibility for that person's well-being.
And they're to monitor that person's well-being?
Yeah, they take reasonable steps to ensure that person's well-being, sure.
And in your report, you never mentioned the risk of positional asphyxia, did you?
I don't believe I did.
And you never mentioned the risk of, to Mr. Ellis, of hypoxia in your report?
I may not have.
And you never mentioned the foreseeable risk to Mr. Ellis of being in a 4-point restraint with over a 200-pound officer on his back?
Can you repeat that?
In your report, you never mention the risk to Mr. Ellis of being in a 4-point restraint, prone with a 200-pound officer on his back.
Yeah, I don't know if I agree with that characterization of the events, but I didn't write that.
Just a moment, Your Honor. I don't have any further questions at this time. We have just minutes to rest of the other opposing counsel.
Okay. Mr. Husser?
Good afternoon, how are you, sir?
Good afternoon, I'm well, thank you.
Mr. Nielsen, Ms. Nicolavo asked you about whether you trained at the CJTC and those sorts of things. Do you train local law enforcement?
I'd have, yes.
And explain in what capacity and what those duties include.
There's been many. The most recent probably, I was on the state SWAT training cadre, and so I did that for many years.
Okay.
I did that twice a year for a week at a time, and then many times on a much smaller scale throughout my SWAT career. And then when I got promoted, I came off the SWAT team.
And do you train local law enforcement agencies with respect to use of force?
Some, yes.
Describe that for us so we can have a context through which you do that.
A lot of it is like grappling type force. We do a lot of sparring, so we do a lot of rolling, like that kind of stuff. And as you go through, and most specifically at my agency in particular, I vet the training. What do you call them? The training plans, essentially, right? I vet them for current practices and in compliance with generally accepted principles. And not only so on the paper side of that, but then I also help carry that out on the practical side as well.
So you prepare the lesson plan, we'll say, and then the practical application?
I prepare some lesson plans. The ones that I don't prepare, I review them for how can I say it, for compliance.
Compliance with the national standards, specifically Graham versus Connor?
Well, for sure that, yes, but also tactically too.
Okay.
So yeah, Graham is the legal portion, but also like the mechanics of what you're doing as well.
Okay. And then practically, describe what that looks like practically. Is it hands-on with the officers?
It could be, yeah. It could be. It could be that. We do that for not only physical aspects, so like grappling, but also with less lethal tools, tasers, OC, batons.
And does that coincide with the continuum of force that you've discussed both a couple weeks ago and then today?
Yes. So not only do we drill the actual tactics of like how to deploy a taser, for example, but when it would be appropriate to do so. And we do a lot of scenario-based training where you're required to make decisions on level of force or whether to use force at all. And oftentimes we craft scenarios where force isn't an appropriate response. And so it's not all the time that you go into a room and see a guy wearing pads, so you know you're going to fight. We craft them so that the officers have to make decisions on whether to use force or not. And then what kind, then how much.
And it sounds like you don't advise them what they're walking into because that's not what it's like in the field. Is that fair?
We advise them on a scenario, for example. So you might say, Walmart has a person detained for shoplifting, ready, set, go. And then they go in there. So like that, but there's a lot of decision-making space for them by design.
And is that because out in the field it's much more dynamic than in a classroom setting?
Yeah, we try to make it as real as possible within constraints.
Okay. All right. And Ms. Nicolavo asked you about testimony and whether you've testified primarily in defense of law enforcement. And you've actually been retained by experts by the Attorney General's office, right?
I have.
In fact, Ms. Nicolavo specifically.
I did work with her prior.
Okay. In review of the materials related to this case, I want to ask you specifically if you reviewed certain things. Did you review Pierce County Sheriff's Department investigation into the March 3rd, 2020 incident?
Oh, yes.
Okay. Meaning Sergeant Brockway and other detectives that led up the investigation into this incident?
Yeah, I'm sorry. I was trying to reconcile the dates. There were many yes.
Okay. All right. So you reviewed Pierce County Sheriff's investigation? Is that right?
I did.
How about, are you familiar with the term IIT?
Yes.
What's an IIT?
I think it's Independent Investigative Team.
And there was one in this case, right?
I believe there was.
In fact, that was the Washington State Patrol, wasn't it?
Correct.
Detective Rue and Detective Markin for the
I'm gonna
Washington.
object to, one is leading and two is outside the scope of.
Well, it's cross-examination, and
I'm sorry, what's that?
This is cross-examination, and I'm discussing the materials he relied upon, which has been explored by both Mr. Fricke and Ms. Nicolavo.
I take it this is information that was, you're talking about information that was developed with those officers involved?
Yes, sir.
Certainly we know their names have come up before
Yes, sir.
associated with other witnesses. Overruled, you may continue.
You're aware that there was an IIT in this case, right?
I am.
And that was led by Detective Rue from the Washington State Patrol, right?
I believe so. There were 2 State Patrol detectives.
Detective Markin as well, right?
Correct. And they were together. I'm not sure who was lead,
Okay.
but yes.
And you reviewed their independent investigation of this after Pierce County investigated this, right?
I did. There was a lot of overlap. Yeah.
Okay. If I understand, you also reviewed all of the scene photos, is that fair?
There were many of those. Yes.
Okay. All of the video evidence.
All that I know of, yes.
All right. You also reviewed Officer Collins' statement in conjunction with those pieces of evidence, is that fair?
Yes.
Why'd you do that?
Why did I review his statement?
Why did you review his statement in light of the other evidence, either objective or subjective in this case?
It's really important when you're looking. I mean, I'm sorry if this seems obvious, but it's really important to know what was going through his mind, what his perceptions were, and why he was making the decisions that he's making.
And you have to do that in light of the other information not coming from Officer Collins, is that fair?
Yeah, in the context of the entire event, correct.
And you did that in this case?
Yes.
Okay. And so you know then that he provided a voluntary statement on March 9th of 2020, about 6 days after this incident, right?
Yeah, I don't recall the exact day, but I know that he gave a voluntary statement.
And are you aware that that statement came 3 months before any video evidence surfaced in this case?
I am aware of that.
Okay. What, if any, impact does that have on your assessment or opinion or analysis in this case?
Objection, Your Honor. Relevance and credibility.
Oh.
Looks like he's going down the path that we've already discussed.
Did it have an impact?
To a degree, it did.
Okay, you may answer.
Why did it have an impact and then how?
Because when we're talking about settling on a factual universe upon which to make analysis, it was important to me that both the officers made statements far prior than the video coming out, and that the degree to which a lot of what they said was also contained in the video. For example, the close-handed strikes, right? They made all these statements with no knowledge that there was a video in existence.
Right.
And so if there was ever an opportunity to distort things,
Your Honor, it continues to go down the path of making credibility determinations.
We may be going a step too far here. I'll sustain the objection now.
Right. Fair to say that you considered what those statements were in light of the unavailability of any video at the time that they made the statements. Is that fair?
that is fair, yes.
All right. Let's talk about the video for a minute, because Ms. Nicolavo spent a lot of time asking you about what was not contained on the video. Do you remember that line of questioning?
Yes, I do.
Ms. McDowell's first video was approximately 36 seconds, right?
I believe so.
And how much of the video actually showed the interaction between the officers and Mr. Ellis? Do you know?
I think a fair bit less than half.
Yeah. Because she turns around and starts yelling at Mr. Lowry, right?
Yeah, and the video's dancing all over the place, and I think my recollection is like 14 to 16, 18 seconds of actual viewable footage of the entire thing.
Okay. How about her second video? How long was that one?
That one was shorter. I don't.
How about 13 seconds?
Yeah, that sounds about right. I don't know it was that short, but that sure.
So less than a minute of video from Miss McDowell. Is that fair?
Yeah.
How about the Vivint video? At least the initial portion that captures Miss McDowell's vehicle and her screaming at Mr. Lowry behind her.
I did see that.
And that's about a minute of video or so?
Yeah, that one was kind of fragmented, I think kind of choppy because it was motion activated, but I remember seeing that.
And how about Mr. Cowden's video? That was about 50 seconds, wasn't it?
Yeah, that was the longer whole video.
And Mr. Cowden's video overlapped substantially with Miss McDowell's video, you would agree, right?
Yeah, there was some overlap. I think that there was also some things that while Ms. McDowell was yelling at Mr. Lowry that was happening that she wasn't catching.
Sure.
Yeah.
All right. So total, less than a minute of all the video combined of the incident that we're talking about lasted more than 3 to 4 minutes, right?
Correct.
So Ms. Nicolavo asked you if certain things weren't captured in that video, and you agreed with her, right?
Yes.
Because what was described and what she was asking you about, at least according to the officers, happened prior to anybody recording the incident. Is that fair?
That could very well be.
Well, you reviewed Officer Collins and Officer Burbank's statements, right?
I did.
And what they described and what Ms. Nicolavo was asking you about, at least in their recitation of the facts, happened prior to the elbow strikes that are seen on the video, right?
Yeah, the fight was well underway by the time the video happened.
Okay.
So my impression was there was a lot that happened before they pressed record.
And there's no video evidence of what initiated the contact between Mr. Ellis and law enforcement, right?
As far as I know, that's correct.
Did you also review Sergeant Lim's statements in preparation to make an analysis or an opinion in this case?
Yes, I did review Sergeant Lim's statements. Yes.
And so Sergeant Lim would have been the direct supervisor of Officer Burbank and Collins. Do you understand that?
Correct. Yes.
Okay. And do you understand that he appeared on scene shortly after Officers Ford and Rankine?
Yeah, I knew that he was on there pretty quick after Ford and Rankin arrived rather.
And are you aware, or did you rely on forming your opinion that Sergeant Lim describes observing Mr. Ellis, I think his exact words were, attempting to kick his legs around?
Objection, Your Honor. Hearsay.
You asked him about efforts that Mr. Ellis may have made to strike somebody and so on in your examination. So,
Based on the video and what he had reviewed on the statements, this is a witness that hasn't testified.
it's all evidence. Overruled, you may continue.
So you're aware that Sergeant Lim described as he's present before hobbles are applied, right?
Yes.
And one of the things that he describes is Mr. Ellis kicking around with the officers trying to restrain him, right?
Yeah, I think there were many different accounts of that behavior.
Okay, and one of the things Sergeant Lim said is that Mr. Ellis was attempting to stand up with these officers as they were either holding his legs or holding his torso, right?
Yeah, I vaguely recall that.
And described the amount of strength that he observed in this process, right?
Yes.
Did that play into your opinion about whether force was necessary post handcuffing to restrain or control Mr. Ellis?
Yeah, he clearly wasn't under specific control. He clearly had freedom of some movement.
And is that a distinction that allows for continued use of force despite handcuffs being applied?
Yeah, and again, it has to be reasonable.
Okay.
Yes.
Why? Tell us why.
There's a variety of reasons, and Ms. Nicolavo briefly touched on the idea that once the person is into your custody, you have a duty to care for them.
Mm-hmm.
And so it would be wholly inappropriate if Mr. Ellis is continuing to flail around in handcuffs and they just sat and watched.
Right. Why?
For a variety of reasons, but mostly his safety, right? And so if you have someone who's gone that far, acting that irrationally, and they start banging their head into the pavement or flailing around or rolling out into traffic, you have a responsibility to do something about that, to intervene, right? And we talk about it in terms of force, and it could be characterized that way, but if you're holding the person, right, even if you're just holding them with your hands, or if you kneel on a portion of them or put weight upon them to stop them from doing that, that's a wholly reasonable tactic to control that behavior. And it can't go uncontrolled.
Right. Well, Ms. Nicolavo suggested that there has to be some sort of immediate threat to the officer to continue to apply force. Is that accurate?
No.
Why?
For that reason. And oftentimes there's not a threat component to the use of force. And the most poignant example, the easiest example, is that when the person's offering passive resistance. So you might have a protester laying in the street would be a good example. Right? There is no, you have traffic stop, and assuming there's no threat and the person's not attacking the officer, you'd have to take some measure, some physical measure, to remedy that problem. And if you pick the person up, and they don't kick at you, and they don't spit at you, and they don't try to headbutt you, you could justifiably carry that person away, even though there's no threat. Now, the force used has to be reasonable in that context.
Right.
So if the person's laying in the street and you hit him with a stick, that's not appropriate. Right? But if you pick them up or you try to carry them, even in the absence of a threat, then that would be wholly appropriate.
And so it would, if I understand you correctly, it would be improper for officers in this circumstance not to continue to restrain Mr. Ellis when he's kicking and flailing and trying to stand up while he's cuffed.
Yeah, I guess you have a decision to do nothing or to somehow fix it.
Okay.
Right? And if you do nothing and he smashes his teeth out on the pavement, then you own that outcome. You're responsible for that as the police officer on scene. If he smashes his head on the pavement and gives himself a concussion or a skull fracture, you own that outcome, right? And so you have to do something in order to make sure that even if it's his own volitional acts, or you have to make sure that person is safe. They're not going to get hurt.
One of the things that Sergeant Lim described was that Mr. Ellis was attempting to stand up with these officers, trying to control him. Is there a risk if Mr. Ellis is able to stand in the context as described by Sergeant Lim?
Yeah, anytime someone is handcuffed, right, they don't have the ability to brace themselves, and so you can't allow them to go mobile and to be moving around a lot, because if they fall, they can't catch themselves.
Right, they're at risk to skull fracture or something if they land on their face, right?
Yeah, and that happens. We've had handcuffed people run away, and they trip and fall and break their face, and you own that outcome when that happens.
Okay. Does the location that Mr. Ellis is restrained in come into play when determining whether some force is necessary to prevent these sorts of things?
It could, for example, if he was in a landscaped bark, flower bed, where it's softer, it could. You would still not let him flail around, but that could impact like what you do to control it.
Well, you understand in this circumstance, Mr. Ellis is in the middle of an intersection, right?
Yeah, it's a paved public roadway.
And traffic's coming in the lane adjacent to where Mr. Ellis is being restrained, right?
Yeah, there was, at least at the early onset, there was no traffic control.
Yeah.
Right? And then as it came, it probably developed, but there was no means of controlling traffic.
Is there a risk that Mr. Ellis is hit by a car if they don't restrain him while he's handcuffed?
It could. Yeah, anytime someone's laying in the public roadway, there's obviously risks associated with that.
In your, Ms. Nicolavo discussed your report. In your report, you discussed excited delirium. What's excited delirium?
Excited delirium in the context of law enforcement it's like a universe of physical symptoms, right, that manifest concern. And there tend to be a lot of the similar kinds of symptoms, right? And again, as evolution training evolves, that constellation of symptoms it still exists. We call it something different now. But still, when you see people exhibiting those behaviors, right, there's certain training principles that go along with those behaviors.
And does that inform your opinion about what's an appropriate use of force if somebody's exhibiting the symptomology that was generally associated with excited delirium?
Yeah, excited delirium people are scary people.
Why? Tell us about it. What's the symptomology and why is that significant to the use of force?
The most
This is outside the scope. There was no questions by either Mr. Fricky or myself about excited.
No, but there was a lot about use of force. Proceed.
How, if at all, does the symptomology associated with excited delirium impact use of force and the assessment of whether it's appropriate?
Well, like I said, excited delirium they're scary people. That's typically a multiple officer response because they don't feel pain. They're strong. Their decision making is radically impaired. There's no reason or cause effect understanding, causal understanding of behavior, and they're super hard to control. And that's the physical component. And then there's the health risks that go along with that too.
Well, we're going to talk about that in a second because
Okay.
there's also creates a medical emergency as well, right? Potentially.
Yeah, once the person's secured, but before they're secured, that's a scary call.
All right. In this case, did you have information from the officers who responded and had contact with Mr. Ellis that he was exhibiting the symptomology that you've described associated with excited delirium?
Yeah, my understanding was that at least Rankin was one of the earlier ones to say this might be excited delirium, and I think Ford too when Ford arrived. And again, we can go through the symptomology if you want, based on my understanding of it, but this fits that criteria.
Yeah, we've gone through it ad nauseum. I don't need you to go through it again in front of the
Okay.
jury, but you recognize that was a component of use of force in the decisions in this case.
Yeah, excited delirium cases very rarely resolve without a fair amount of force.
Okay, all right. Now you said also it has a component of creating a medical emergency. How so?
It's a metabolic condition with the person, right? And so typically their body temperature is super high, their respiratory rate is super high, right? And so and typically there's a drug component to it. There's typically methamphetamine. And so there's that, and you never know how much of that's on board. And so once you get the person controlled, and this goes back to the life safety priorities that I was talking about with Mr. Fricky, is that the paramount concern is that person doesn't go out into the community and wreak havoc in the community, right? The more that you can make a law enforcement event kind of one-on-one, we exclude the community, and it's just the cops and the person, right? That's what we endeavor to do, because you don't want innocent people to get hurt. Excited delirium people are so unpredictable. You have to isolate them as soon as you can, and then once you get them contained and the scene is safe, then you bring in medical personnel. And I don't know if that's been addressed, but the medics won't come in.
We're going to get there in a second.
Okay, sorry.
All right, yeah. So the training and at least as far as use of force, as I understand it, in a situation where there may be symptomology of excited delirium, you okay? They have to control and restrain that individual. Is that fair?
Stabilizing the scene is the first thing that you do when you get there, and that would include controlling the person.
And that's because they can't even seek medical aid until that individual is under control so that those providing aid are safe as well. Is that fair?
Correct. And no medical personnel, the medics, the fire department, MHPs, mental health providers, none of those people will come until it's safe. And if you do let them come, then you own that outcome too. And so if a firefighter comes in and gets stabbed because you didn't sufficiently secure the scene, then you own that outcome as well.
Are you aware in this case that Officer Collins met the medics when they arrived on scene and suggested that Mr. Ellis was suffering from symptomology of excited delirium?
I vaguely recall that.
Is that appropriate, given the duty of care that one would have to somebody in that circumstance?
Yeah, I think you'd want them to the medics to know what they're walking into.
And to suggest that there may be some urgency with respect to treatment, right?
Yeah. Once he's detained, and if it's an excited delirium type event, yeah, you'd want them to take over as soon as they could.
Because that could affect the medical treatment that follows in that circumstance. Is that fair?
Yeah, the timing and nature for sure.
Understood. In your report, you use a term crisis event. What's a crisis event in use of force analysis?
typically, and I've kind of changed the way I've talked about that a little bit, but typically, there's a variety of crises that we deal with in law enforcement, right? And they can be, like I think I talk about, like weather events, right, or mechanical crises, vehicle collisions, things like that. That's one class of crises that we respond to, but the most common class is conflict, conflict between people.
All right. Is this what you know about the incident with Mr. Ellis in Tacoma Police Department? Would you characterize that as a crisis event?
To distinguish from a mental health crisis event, that's a different kind of crisis event. But yes, in the context that I discuss it in my report, yeah, you have competing wills, right, with disparate goals.
Okay.
Each party to the conflict wants something different to happen.
Okay. And in this case, does the actions of Mr. Ellis impact in that crisis event the modality of use of force from the officers trying to restrain him? Does that make sense?
Can you rephrase that?
Yeah. Does the combative nature of the subject in the crisis situation, in this case Mr. Ellis, affect the use of force by the officers, potentially?
Well, not potentially, but certainly.
How so?
Because like you and I could have conflict, and we could talk about it, maybe, right? If we're rational people, and we could discuss it and maybe resolve it that way. You know, if you throw a binder at me, now that's a different kind of conflict, and we'd have to have a different way of maybe resolving that kind of conflict. And so it not only the physical resistance, but the type, the intensity, the duration of the physical resistance, that all shapes the officer's response to resolving that conflict.
And is that officer response dependent on, for instance, in this case, Mr. Ellis's conduct?
It's wholly dependent on, yeah, like the police officers are always responsive to the resistance they're getting from the person.
Okay, in your report you use the words radically shape resolution strategies available as it relates to the subject's conduct. What do you mean by that?
Because the subject is always the driving factor in the use of force event based on the type of resistance, the nature of resistance, their intent, their motives, those kinds of things.
Okay.
You know, keeping in mind that the police officers tend to show up to things that they have no idea what's happening, and they're the least informed people in the conflict.
And the description of Mr. Ellis in this case, is it consistent with him being irrational and combative with the officers?
Yes,
Okay. Dictating their use of force then?
very much so.
Now, Ms. Nicolavo suggested that once the risk is gone, the use of force must cease, and you declined to accept that proposition. Why?
Again, as we kind of talked about before, that you can use force in the absence of risk, but like using that type of analysis, for example, if I point a gun at you and I fire it at a nice easy cadence, 1, 2, 3, you could say that the space between each gunshot, you're no longer a threat.
Right.
That's nonsensical, right? If I punch you and then stop, and punch you again and stop, and punch you a third time, you could say that the space between those punches, you're no longer a threat. And that not only doesn't make sense, but doesn't make for a meaningful analytical framework to evaluate force events.
Well, let me ask you this. Jack Ryan, the state's expert in this case, used still photographs of Mr. Ellis with his hands up and suggested there is no threat at that point in time. Is that how you analyze use of force in this context?
No, not remotely close, no.
Why?
Because if the video footage is taken on an iPhone, right, which shoots at about 30 frames a second, what you show me is 1/130th of a second in time, and ask the person to make a judgment based on a 1/130th of a second moment in time. Not only do humans not perceive information in that way, right? You wouldn't even know what 1/130th of a second in time would look like based on an interaction.
Right.
I'm sure you've had the displeasure of having an unflattering photograph taken of you, right? It's that you've seen.
Not me, but I've seen it.
Right.
Objection. Responsive, overruled. You may continue.
Go ahead.
But that's my point, is that moment in time, you know, it doesn't lend any analytical weight to the event.
Right.
Now, there might be some characteristics where the officer said, I saw him reach for a gun, right? That when you watch the video at full speed, that you miss that, and maybe you parse it up that way. But in this case, like there was the photo of the hand on the neck.
Yeah. But that was described as my client choking Mr. Ellis, right?
Yeah, that strains credulity. That's a hard one.
Okay. How about any opinion based on a moment in time, not taking into account the context of everything that led up to that moment in time. Is that the appropriate way to assess use of force?
No, it's not, because you have to, the universe of events that's known to the officer at the time, right? So, I mean, there could be any number of things that the officers perceive as being gravely dangerous, and then you take a 1/130th snapshot of the whole event that could look like it was completely innocuous,
Well, we've seen it.
and so that's my point.
Comments on the evidence by counsel.
Mr. Officer's comment should be disregarded by the jury.
That's my point, is that not only is that not how force decisions are made, but it's not how they're meaningfully analyzed after the fact.
For instance, if Jack Ryan opined that in the first McDowell video, Mr. Ellis is laying on his back at the time that Officer Collins delivers an elbow strike, is that the context through which that use of force should be evaluated?
Just that, no, it's
Why
not.
not?
Because you'd have to know what led up to that, right? You'd have to know why Officer Collins was striking with his elbow in the first place.
Okay.
Like, for example, all the failed uses of force that happened before that. Like, if you just show a 1-second snippet of a guy getting elbowed in the face, that there's not enough information there to make any meaningful analysis of the event.
Judge, I don't know if we want to take our afternoon break at this point, but I'm going to transition to the playing of the video next, so that might be a good time.
Okay, we can do that. Right, we'll take our afternoon recess for 15 minutes, ladies and gentlemen. Please discuss case.
Yeah, I'm like,
All please rise.
Okay, welcome back, everybody. Please be seated. Okay, Mr. Usser, continue when you're ready.
Mr. Nielsen, before we get to the video, I want to go over a couple things for just context purposes. Ms. Nicolavo asked you, and I think you disagreed with the form of the question, that officers must exhaust every lesser force option prior to choosing the most likely effective. Do you remember her asking you that?
I do.
Your Honor, Mr. Chairman.
Overall.
I do remember that, yes.
Something along those lines.
Yes.
And why did you disagree with that proposition?
So that's a very antiquated kind of way of analyzing force, and it used to be the continuum of force, right, where you start at the low end and then work your way up through a series of options until you get to the one that is necessary for the moment. And so if for example, you're being punched in the face, it wouldn't make a whole lot of sense if you wanted that to stop, to give the guy commands, stop punching me in the face, which would be the very first option on the force continuum, right? Is that's where you would start, and then maybe you try to gain wrist control of the person while he's punching you, which would be the next step up on the force option. Meanwhile, you're getting pummeled. So you meet the force option that you choose is designed to meet the resistance that you're getting,
Okay.
right? And then go slightly above, like we talked about before.
And I think you described that earlier as most likely effective given what force you're faced with. Is that fair?
Yeah, correct. Like if a person's pointing a gun at you, you wouldn't, pull out your baton,
Okay.
which would be a progression up to that point.
Okay. In your opinion section, before we get to the video, you describe that a reasonable officer would find Ellis assaultive, and you use the word assaultive. Why do you use that word?
Well, at the outset, when he said, "How about I punch you in the face," and started striking the window,
Okay.
like at the outset, that's the onset of that assaultive conduct.
And so why is assaultive, the characterization of Mr. Ellis's conduct, significant to the application of force?
That's a much different level of resistance.
Okay.
When it becomes, so if you have what you might say aggressive, which is running away type resistance, It's active resistance, but the person's trying to escape. That's different than aggressive, which is the person is coming at you. That's a much different scenario.
And where a subject is assaultive or combative, where does that dictate the level of force that is reasonable for somebody facing that? Does that make sense?
Yeah, and it depends. Like if the person spits in your face, that's an assault, right? So you probably wouldn't hit them with your baton at that point. But if they're striking you or trying to tackle you, or they're actively like trying to pull you to the ground, that's a much different level of force. I mean, you're going to go up pretty quickly.
Right, and so we've seen the TPD policy with respect to use of force, and included in the intermediate forces are taser, baton, LVNR, those types of uses of force. Is that fair?
Correct. Yeah, and that's pretty typical.
Okay, and so is that appropriate where you classified the subject's behavior as assaultive or combative?
Yeah, that's not really a close call. Yeah, if a person is assaultive toward you, you could go to taser pretty quickly.
Okay.
Yeah.
And so I talked before we took the break about the context in which the entire incident occurs dictating when that force is no longer necessary. Meaning, if somebody like Mr. Ellis is assaultive, does the fact that he's on the ground mean that officers cannot use that same level of force to control or restrain him?
Well, it would depend,
Okay.
right? I mean, it would depend what he's doing on the ground. And so if he's punched you a bunch of times and he's still not giving up,
Yeah.
right? Or if he's assaulted you and he's still not giving up, then you know that like that's in the context of the event. And so it's not unreasonable to think if he's punched me once before and he hasn't given up and he gets away, or I don't control him, I may get punched again. That's the context that you have to evaluate that in, right?
Okay, understood.
And that goes back to like the risk part of the gram factors.
Understood. Okay. One more thing before we get to the video. In your report, you discuss categories related to cuffing an individual, and I think you list them as compliant, non-compliant, and high risk. Can you tell the jury what you mean by those three things, and then we'll talk about what's appropriate here?
Okay, so compliant handcuffing, which almost across the board is typically not a use of force. And so that would be, you walk into Walmart, has a shoplifting suspect detained in their office, you show up, you say, hey, I'm Officer Nielsen, Renton Police Department, go ahead and face away from me and put your hands behind your back. And the person does it, and you put handcuffs on them.
Okay, so that's compliant cuffing.
Yeah, and that, frankly, is how most of them go,
Okay.
Yeah, and then you have non-compliant cuffing.
What is non-compliant cuffing?
That's when you have to, then you're using force to put the person, they don't want to be handcuffed. And so again, you have to modulate the force depending on the resistance that you're getting. But it's much trickier because you have to control the person before you handcuff. And this is something that you see a lot, is that the cops go quick to the handcuffs, but you have to have the person under control because you don't want them flailing around.
So explain that, because in your report you discuss the higher risk of injury if you don't gain compliance prior to cuffing. Why?
Not only to the officer, but to the person as well. So if the person is not under control and I get one handcuff on you, and the person starts to flail around, right, and that hook on the other handcuff gets you in the eye or gaps you in the face or hits you in the head or hits the person, right? And that's a real risk that happens. And they also have it too. Then if they get away from you, they also have it, and you could grasp that thing like brass knuckles. You could use it as a weapon aggressively, and that's why you get the person controlled, and then you apply handcuffs.
Okay. To reduce risk to the officer and the individual?
Yeah.
And then what's high risk?
High risk is so high risk could be like it could be a scenario where the person is not actively like resisting. So you could say, for example, if you pull over a person in a stolen car, right, and you're going to take that person to custody, you would probably do a high risk scenario, which might mean you bring them, you verbally tell them to get out, walk backward toward you, lay down on the ground, right? High risk cuffing and prone cuffing, that's a very close, a lot of overlap there.
Okay.
Although you could do high risk cuffing from like a kneeling position if the person's compliant.
And in your report, you talk about application of knee to the spine, shoulder area to gain compliance for cuffing. Is that standard?
When you do prone cuffing,
Yeah. Why?
and I couldn't even begin to estimate how many repetitions at the police academy you do prone handcuffing. That's a very fundamental skill that you don't get out of the police academy without doing it hundreds of times, prone cuffing people.
And why is the application of the knee to the spine, back, or shoulder significant in the cuffing process?
it controls most of the shoulder girdle, right? So you're trying to gain control of the person. If they're face down, it prevents them from pushing up, from turtling their hands underneath them, right? And so you gain control of an arm, and you can moderate pressure based on how the tactics you use. You can moderate pressure on the person depending on whether they're resisting or not.
Does the use of force in that location limit the amount of leverage the subject can gain to resist at that point in time? Does that make sense?
Yeah, especially because how you're trained to do it is you put the person's shoulder girdle between your legs, so their hand comes up between your knees, right? And you kneel one either on their upper shoulder or on their clavicle, their lower shoulder, right? And you can moderate that. You can put one knee on the ground depending on how it goes, but the hand comes up through the middle of your groin, and when you're in that position, it's hard to move around that way, and that's by design.
And the design is to prevent the use of force from the subject in that location, right?
It's a really good control position for handcuffing, to control that person before you apply the cuffs.
Okay. The last thing before we get to the video, you describe in your report that Officer Collins demonstrates, I think you said, high proficiency of ground control. What did you mean by that?
Yeah, so when you watch the video, and then in some of the stills that I was shown too, those kinds of skills aren't taught at the base level of kind of grappling. You know, heck, even like if you wrestle as a sport, you don't even get into those levels until you kind of progress in the sport of wrestling for a while. And so, like, I could immediately identify what he was doing if I didn't even know his background. I would say, okay, that. And when you wrestle with people, you know if they have skill. I mean, you can tell pretty quick. And when watching that, I could tell that he had a kind of an advanced level of training.
And in viewing that video, did it seem appropriate what he was doing in an attempt to control Mr. Ellis as you described?
Especially in the context of the LVNR, that would be like the by the book way of doing an LVNR in that position.
Okay, we'll talk about that in a second. Okay.
Okay.
With the court's permission, I'm going to publish Exhibit 20. And Exhibit 20 is McDowell #1 video. Okay. And with the court's permission, Judge, can he step down to the monitor here, and I'll tilt it towards the jury so he can explain what we're seeing.
Proceed.
There should be a pointer somewhere. All right, Mr. Nielsen, if you can just orient us to what we're looking at and what is significant to you when we hit play. Because I'm going to play it through, and then I'll have you come through and describe what we're seeing, uses of force, and why you found that was appropriate, okay?
Okay, so at this point, the three men, the two officers and Mr. Ellis are away from the vehicle, kind of at the vehicle, if you're looking at the top, it might be the 2 o'clock position of the vehicle, which is just off the front right quarter panel.
Okay.
And the officer's back is to us. I think Mr. Ellis is between the two officers at this point.
And any idea how long the struggle had been going on between these individuals before Ms. McDowell started shooting this video?
I mean, I could surmise just based on the statements of the officers, but I mean, it's hard to tell.
Okay. And so we see Officer Collins back towards us between Ms. McDowell and Mr. Ellis and Officer Burbank. Do you see that?
Yes.
And can you tell us, or can you see where Officer Burbank is in this video before we hit play?
It's hard to tell. There's a shadow,
Okay.
which is from probably the lights, but it looks like a shadow, or maybe actually that might be him. It's hard to tell.
Well, we'll hit play in a second. Okay, but they're in that vicinity
Correct.
past Officer Collins. Is that fair?
Yeah, I
Alright.
think it goes from the order of the view, the perspective of the viewer. It goes Collins, and then Ellis is maybe just kind of off to the side, and then Burbank.
Okay. And before we get there, you reviewed Officer Collins' statement in conjunction with this video, right? And in Officer Collins' statement, he describes the struggle. At some point, he pops up. Those are his words. He pops up and then gains tactical advantage on Mr. Ellis's torso. Is that what we're going to see right here?
Yeah, I think this is, at this point, if my memory serves me correctly, I think there's kind of a semi-takedown type move by the officer with his back to
Okay.
us.
Well, let's hit play. I want you to watch it, and then I'm going to ask you some questions.
Can I dictate that?
Let's watch it first, and then I'll play it back, and you can dictate, okay? That way we can see it through and get perspective.
Got it.
Sean, go ahead and play things.
Hey! Stop! Oh my God! Stop hitting him! Hitting him! Just arrest Oh my god, that looks so scary! Shut up! You have kids in the car.
All right, go ahead and pause. Go back to the beginning, please. All right, so Mr. Nielsen, can you tell us what you're seeing and what the significance is in forming your opinion about the appropriateness of the force by Officer Collins and Burbank in this video?
Okay, so.
Can I ask the audio be played with it, or is it, I can't hear the audio.
I don't mind, it's your presentation though, counsel.
So go ahead. Tell us what we're going to see and what the significance is in your forming your opinion.
So what's telling is that if you just stop the video once they go to the ground,
Okay.
there would be a lot of like, I want to know what preceded that, what precipitated that, why did you do that,
Okay.
right? And
Well, let me ask you this. Based on the officer's statements, you understand that Mr. Ellis was both assaultive to the vehicle and Officer Collins preceding this. Is that right?
well, yes, that's true.
Okay. And so what, if any, impact does that have on the use of force we're about to see and the appropriateness of it?
Yeah, if you take the version of events as I understand them as relayed by the police officers, I mean, this is a very high risk event. I mean, he's attacked the police vehicle. They're outside the police vehicle now. He hasn't, nothing that they've done so far has controlled him.
Okay.
And so now they go to the ground. And then even once they get to the ground, then it's the resistance continues.
Okay. Officer Collins describes in his statement, and is consistent with the video, that he delivers multiple elbow strikes. Do you see that in this?
Yeah, if you play that again, and I don't recall if the elbows or close fist strikes.
Okay. Can we play it one more time for Mr. Nielsen?
Hey!
All right, go ahead and pause it.
Stop! Oh my god!
Were you able to tell if that was a
stop
closed
it!
fist or elbow?
It's hard.
Okay.
It's hard. It could be either one.
All right. And I think you said that.
As a force principle, it's not going to make a whole lot of difference whether it's a close fist strike or an elbow strike. Those are just varying degrees.
But on the continuum that we've talked about, if I understand, that's appropriate given what was described preceding that interaction. Is that fair?
Yeah, my understanding is that nothing else worked up until that point.
Okay.
And what you do, and also what you see is you don't see him become defensive.
Right.
So those strikes, you don't see him turtle up, you don't see him stop, or try to, like I said, become defensive.
Okay.
That's concerning.
When you say him, you're talking about Mr. Ellis at this point.
Yes, sorry.
Okay. And you know, based on Officer Collins' statement prior to seeing or knowing this video existed, he then describes Mr. Ellis lunging up through him as he's doing this, and they both fall on their side and face the middle of the intersection. Is that right?
Correct. Yes,
Okay.
and I think that's where the Cowden video starts to pick up from that perspective.
All right. Can we put 546 up, please? All right, 546 is the compilation, or at least part of a compilation timeline prepared by Mr. Fredericks. You've seen this, right? All right, can we play up to the point where Cowden's video shows in the center of the screen? All right, go ahead and pause it, please. All right, are you familiar with that center video section?
Yes,
All right, and is that from Mr. Cowden's perspective?
that's my understanding.
Okay. And can we turn the volume up on this, please?
No, it's not playing.
And before we get there, Mr. Nielsen, so in relation to Exhibit 20 that we just saw, Ms. McDowell's first video, there's some overlap now between what we're going to see and the timeline that was seen in that video. Is that fair?
Yes.
All right. And so, and any indication how Mr. Ellis, well, can you show us where Mr. Ellis is in the video?
Yeah, he's in the center of the frame, in the middle video. He's in the center of the frame wearing yellow pants.
And Officer Collins is now behind him on his side, facing the intersection as he described before any of the video existed, right?
Correct.
And any idea how they got into that position from the one we just saw where Officer Collins was on top of him and delivering strikes?
My understanding was, as he said, that Mr. Ellis tried to get up,
Okay.
and that kind of resulted in Officer Collins going behind.
Okay. So what I want to do, Mr. Nielsen, I want to play this through with the sound and then ask you some questions, and we might go back through it again, okay? Can we hit play, Sean? Thanks.
Hey, you're on the wrong way now! You got kids in the car, you dumbass, you already know. Henry 217? 37. No, 6 majors. Alright, traffic Henry 317 on trouble 969, we're 2622. Try again, go around them.
All right. You've seen that before, right, Mr. Nielsen?
I have.
Okay. A couple things. Mr. Officer Collins describes, well, let's be exact. What he actually described was attempting to apply an LVNR. That's how he described it, right?
As far, yes.
And that he attempted the LVNR until he saw Officer Burbank in front of him with a taser. Is that fair? Is that fair?
Yes.
And we see that in video, right?
Yes.
And at no point does he ever indicate that he actually applies an LVNR, does he?
Yeah, my understanding is it wasn't able to get it.
Right. What do you mean by that? Wasn't able to get it?
Well, there's a progression. I could just walk up to you and do it, right? But if you start fighting back with me, there might be some back and forth before I'm able to secure it, if at all.
Right. And what Officer Collins describes and is actually shown in the video is he attempts to get the LVNR on and he reaches for his left bicep, but then has to stop applying or attempting to get it on because of the taser. Is that right?
I mean, generally, I don't, with that level of specificity, I'm not sure.
It's okay. It's been admitted. They've heard the statement, okay?
Okay.
And we see that in the video, right? We see Officer Collins attempting to grab his left bicep.
Yeah, we see Collins from behind, kind of trying to gain control underneath or over the arms of Mr. Ellis.
And his body position relative to Mr. Ellis is not consistent with being able to apply the LVNR, is it?
Can you ask it again?
Yeah. So in the video, we see Officer Collins kind of at the side trying to get behind Mr. Ellis completely to apply the LVNR. Do you see that?
Yeah, and the point at which she's able to start to sink his legs into him, and that's when it starts to be a much better position.
Right. So up until that point in time, he can't even apply an LVNR appropriately, can he?
Not with the level of resistance that you're getting. It's pretty dynamic.
Okay. All right, and so we see the initial taser application, and I don't know if you've seen this, but the taser applications on the left, they light up when it's active and then they turn off. Did you see that version of this timeline?
I know that they were noted. If they changed color, I'm not sure if I knew there was a significance in that.
Okay, so tell us, at least from Officer Collins' perspective, the use of force he's applying prior to that application, the attempted LVNR, is it appropriate or not given what you've seen and the context leading up to this?
Wholly appropriate, and one of the notions that's kind of out there is that Mr. Ellis wasn't resisting. This is what resistance looks like. Okay, that's just not true.
Okay. And when you say
Him not resisting would be like would be complying, would be putting his hands behind his back. This is not that.
well, we had Mr. Frederick say that when he put his hands up like this, he was surrendering. Is that what you're seeing in the video?
No, I saw that, and again, if we frame that out, that might be a second and a quarter, maybe a full second.
Okay.
And it's unclear to me whether Officer Burbank, who had the taser, would have even perceived that happening based on where he's aiming the taser.
Right.
And that's not surrender.
Did it appear responsive to maybe Mr. Ellis seeing the taser in front of him?
It could.
Okay.
It could. People, when you draw the taser, I mean, they know it's not pleasant, and so sometimes that happens.
We see Mr. Ellis after the taser application or during it go like this with his hands. Have you seen that before from people who are being tased?
Yeah, so what you have with that is was when the wires come out, and depending on the model of the taser, some of them you get all the wires, and so if you have the 25-foot leads, and I'm standing 6 feet from you, you get 25 feet of wire, so it's all over you. And it hurts too. The taser wires aren't insulated, so that also hurts. And people also know that they can defeat it if they break the wires. If you break the wire, the taser won't work anymore. From that, I could touch you with it, it will still work, but from a distance, if you break the wire, the taser is no longer effective. And so it's pretty common street knowledge that you can defeat the taser by rolling out of it or breaking the wires.
Okay. We heard and you described, if we could go back to the beginning of Mr. Cowden's video one more time. Earlier in your testimony, you talked about hearing Mr. Ellis say, "Do it again" or "Try it again," and that was scary. Tell me, one, first off, do you hear that in this video? And two, what about that causes you concern?
When we were just listening, I didn't hear it in this video. I know it exists, but I didn't pick it up.
Okay.
But that's very frightening. When you tase somebody, like I said, it hurts a bunch. And I can count the times on one hand when someone has done something like that, and it's never been benign.
Okay.
It's always a very scary event with it. So if you tase somebody, and I'm telling you, it hurts very bad.
Okay. Well, I want to play it again. I want you to listen for the time in which Mr. Ellis says, "Try it again." Go ahead, Sean, if you can.
Oh my God! Stop it!
7317, go ahead.
Oh my God, that was so scary! Hey, you're on the wrong way! You got kids in the car, you dumbass, you already know.
7317. 37. I'm not 6 majors. Alright, traffic Henry 317 on trouble 968, we're 2322.
If they killed him. Try again. Go around them. Go around them.
All right, so did you hear it in that?
My recollection was earlier in the event, but yeah, you can hear that.
So it's after the first taser application, but before the second, right?
Yes.
All right, and then we see Mr. Ellis kicking his feet around before the second application. Is that consistent with continued resistance by Mr. Ellis?
Definitely.
And it was suggested by Ms. Nicolava that maybe that was a result of involuntary muscles responsive to the taser application. Do you agree with that?
Not that. No, not that.
Okay.
No, in my interpretation, he's clearly trying to get away. We talked about hip control earlier. That's a really good example. A lot of his energy is coming from the pivot in his hips, right? And so controlling somebody's hips stops that inertia, that ability to do that. And so when you're grappling with people on the ground, hip and shoulder control is key for that. Because if you just let their hips and shoulders flail, it's going to be much, much more difficult to control.
In the same video that we see of Mr. Cowden, at some point you see Officer Collins' right leg go up and over the hip, the right hip of Mr. Ellis. Is that what you're talking about, gaining compliance on ground control?
Yeah, that's one way of doing it. Probably the most effective, but also probably, like I said, the most complicated. So that is a pretty high degree of what I would consider like ground control.
And we see in the video that after the first taser application, Officer Collins push Mr. Ellis's head onto the ground and then grab or gain access with the knee to the back and try to gain control of his left arm. Is that consistent with his statement that he made prior to the video becoming public?
That looks like the beginning of trying to prone handcuff.
Okay.
Is where you capture the person's shoulder and try to get their arm up behind.
And is that appropriate use of force in this circumstance?
This is clearly non-compliant handcuffing.
Okay.
And so there are very, very few, if any, practical ways of doing that from that position. They would all require putting some measure of pressure on the person's back.
When we heard Mr. Ellis say, "Try it again," there was a corresponding movement by Officer Burbank, who was mounted between his legs, and he ends up off of Mr. Ellis. Do you recall seeing that?
Yeah, I think I was right on the time you see his hips start to pivot pretty aggressively.
Okay.
Ellis's hips, rather, not Officer Burbank's.
Okay. It's been described to us previously by state's experts that it appears as though Mr. Burbank just fell off Mr. Ellis. Is that what you're seeing?
Well, no, it's contemporaneous.
Objection, Your Honor, this characterizes the testimony.
Overall, the jury will decide.
That's contemporaneous with Ellis's movements. So I mean, to me, there's clearly a relationship between the two.
And at the time that occurs, Mr. Ellis has his right arm back up by Officer Burbank as Officer Burbank attempts to apply the handcuffs. Do you see that as well in the video when that incident occurs or that portion occurs?
Yeah, and like I said, that's the point at which you're kind of inching closer toward detaining the person in handcuffs.
Okay, all right. Everything we've seen so far, appropriate use of force given everything that led up to this, in your opinion?
Yeah, this is a non-compliant handcuffing situation where the person is clearly non-compliant. And
Okay.
if you take the officer's account, as I have, he was assaulted before that.
And you have to consider that in conjunction with this.
Yeah, you're not going to take a lot of risks with the officer's safety in that situation. You're going, like when we talked about the life safety priorities or the safety priorities, right? The officers are going to take appropriate measures and reasonable measures to guarantee their own safety as well.
All right. Can we pull up Exhibit 21, please. Exhibit 21, Mr. Nielsen, is the second McDowell video as she drives by the officer. Drive by Mr. Ellis and the officer. Have you seen this video? All right, I'm going to play it, and then I want to have you comment on what we're seeing in the appropriateness or de-escalation as it relates to this time frame of the incident, okay? Go ahead and play.
Behind your back. You can get it again. Put your hands behind your back. Hands behind your back. Put your hands behind.
All right, did you hear Officer Collins on 4 separate occasions direct Mr. Ellis to put his hands behind his back?
Yes.
Is that appropriate given how they're situated at that time?
It is, and again, there's a relationship between Mr. Ellis's conduct and the officer's conduct, right? And so if I saw the officer striking him or elbowing him again or kneeing him, then that would obviously be inappropriate because he's not fighting back anymore, right?
But we're going to get there in a second, right? Because at that point in time, Mr. Ellis is still on his side and he's still resisting his hands being placed behind his back. Is that fair?
Yeah, he's.
Your Honor, defense counsel is testifying.
He said, it's leading is what it is, but it's cross-examination. I'll overrule.
Do you see that in the video, Mr. Nielsen?
Yeah, he's not controlled yet. He's not handcuffable
Right.
yet.
And it appears in the video that Officer Collins has a knee on the ground and is positioned directly behind Mr. Ellis's back. Is that what you see?
I don't recall.
Can we rewind it and play it one more time?
Behind your back. You can get it again. Put your hands behind your back. Hands behind your back. Put your hands behind.
Yeah, okay. Yes.
So do you see Officer Collins? He's the one with the beanie hat positioned behind Mr. Ellis's back?
Correct.
And he has a knee on the ground, is that fair?
Yeah, one of the, yeah.
And the other knee is up in the air, is that right?
Yes. He's like in a kneeling position.
And Officer Burbank appears to be in front of Mr. Ellis.
Correct.
And they're giving commands to put your hands behind your back or you're going to get tased again, right?
Correct.
Is that appropriate given the resistance that we're seeing from Mr. Ellis in that video?
Yeah, and whether they tase him or not tase him is a different matter. But if they say if using that tactic gets him to comply, that would be a reasonable thing to do.
Okay.
Keeping in mind that, like I said, the taser hurts. I've said it a lot because it really hurts.
And let me ask you this, one last question about that, and then you can sit down. If they had to apply the taser a third time in order to gain compliance of the hands behind the back, would you think that was appropriate given the continued resistance by Mr. Ellis at this point in time?
If he simply stayed there and didn't put his hands behind his back, and they tased him, I don't think that's appropriate.
Okay.
So if he would have just laid there and they're saying put your hands behind your back, and he wasn't fighting back and just laying there and not complying, then you're more of a passive resistance type of phase. I don't think a taser would be appropriate in that
Okay.
situation.
But if he's actively resisting and not complying with that demand, then another taser application could be appropriate.
Perhaps if they say put your hands behind your back and he starts to flail again and try to get up, then perhaps so.
Okay.
But not with the static at that point.
Okay, all right, go ahead and have a seat. Give me your one last line of questioning, Mr. Nielsen. You're aware that at some point after what we've seen on the second McDowell video,
Can we move that back?
yeah, the officers were able to get handcuffs applied to Mr. Ellis, is that right?
Correct, yeah. Eventually they were able to successfully handcuff him.
All right, and you're aware that hobbles were also used to maintain control of Mr. Ellis post-application of the handcuffs.
I'm aware of that.
And tell the jury why it's your opinion that the application of the hobbles is also an appropriate use of force, given the totality of circumstances here.
Now, keeping in mind when we talk about uses of force and the degrees of force, the application of the hobble is a pretty low level use of force. But like any use of force, it has risks associated with it. But the vast majority of hobble applications don't result in any injury from the application of the hobble. I mean, you maybe get some abrasions on the wrist or something like that, but none that would require medical attention.
Okay. And why would it be appropriate to apply hobbles in this circumstance, given what you know happened after the application of the handcuffs?
He was continuing to flail around. I think one of the officers said he was kind of worming his way into the intersection. That may have been Rankine. And so it's just one more measure of security.
Okay. Well, you're aware that Sergeant Lim appeared on scene prior to the application of hobbles, is that right?
That's my understanding.
And Sergeant Lim described post-handcuff Mr. Ellis attempting to stand up with the officers on his back and on his legs, right?
That's my understanding.
And if that's true, the application of hobbles would be necessary to prevent harm to Mr. Ellis and or the officers, right?
It could be, sure. It could, yeah. I mean, that, or you're faced with having to, again, place weight on him or any number of other things that you could do. And that's a pretty, like, again, it's a low-level use of force. It would be highly effective in what you're trying to accomplish, which is to keep him on the ground and not flailing around.
Okay, last couple questions for you, Mr. Nielsen. There was discussion about duty of care for an individual who's taken into custody. Do you remember Ms. Nicolavo asking you those questions?
Yes.
Would you agree that once Sergeant Lim is on scene that he's now in control of the scene and charged with duty of care to Mr. Ellis?
Yeah, every lawful order or decision that he makes has to be followed. If he goes off the grid and starts making weird decisions, then the officers have responsibilities to act legally, right? But if he's making legal decisions and he's making appropriate decisions, the officers are obligated to follow those decisions.
And is that because it's their superior officer at the time?
Yeah, I mean, he's the ranking officer on scene. He would be the first person in the chain of command.
Okay, all right. Thank you. That's all I have, Judge.
Ms. Bremner?
Good afternoon.
Just wanted to follow up in terms of standards and principles that you're relying on as an expert. Could you explain to the jury what those would be?
Most police departments, right, many police departments are accredited. Okay, and so when we look at the Tacoma Police Department manual, if you look in there's a little notation that says CALEA, C-A-L-E-A, right? CALEA is one of the accreditation entities that looks at, they'll actually come in and audit the police department. They'll look at your evidence handling practices, your records keeping practices, your policies, and they'll audit you and they'll tell you what you need to improve on, or if anything,
Okay.
and then they'll bless you as being in compliant with their model policies. CALEA is one. There are a handful of others. All those principles that are contained in the policy manual kind of coalesce around a general set of practices that are widely accepted in the industry or in the profession.
And is that nationally and locally?
Yeah, and there'll be some variance with that from agency to agency, even region to region. There'll be some variance, but they'll all coalesce around some very broadly accepted principles, like necessity, for example.
And you testified you were a deputy prosecutor,
I was.
and what kind of cases did you prosecute? What was the range from misdemeanors to attempted murder?
Yes, I had it. Yes, misdemeanors to attempted murder. I don't think I ever tried any like sex cases.
Okay, so that would be the same as the prosecutors here.
Yeah, mostly. Not. I never tried a murder
Okay.
case, but attempted murder. I've
And
tried
how long
those
were you a prosecutor?
for 6 years.
And you're obviously a member of local and national law enforcement groups, is that right?
Yeah, correct.
And you've already testified you've been retained by the Attorney General's office as an expert, and then in many other cases, in many other jurisdictions, is that right?
Yes, some by the AG, and then many other cases in other places. Yes.
Let's talk about prone restraint, if we could talk about that first.
Okay.
You just testified about hundreds of times in teaching that prone restraint or handcuffing is practiced, is that right?
Yeah, it's so much so, in fact, that when you go through your OC application, so at the academy they used to spray you with OC, which is pepper spray, another deeply unpleasant experience. But that radically affects your ability to kind of see and do things. You have to be so proficient in prone handcuffing that even after being OC sprayed, you have to go find a person, prone that person out, and do a high-risk handcuffing, even after being OC sprayed. So there's snot and tears,
Okay.
and you're gagging and coughing. Even under those conditions, you have to be so proficient at prone handcuffing, you're expected to do it after being fully sprayed in the face with OC.
And is there anything wrong with handcuffing someone in a prone position?
I mean, if it wasn't necessary, there would be. But if it's a high-risk situation or a non-compliant person, non-compliant handcuffing almost always ends up on the ground.
Okay, and that was really my question, you're ahead of me.
Yeah.
And why is that?
Because if we're operating in three-dimensional space and you're on your feet, maybe I could like push you against a wall or a car or something, but you're still on your feet and you still have a fairly effective degree of mobility, right? If I take you off your feet and put you on the ground, now there's a firm thing that I can press upon to keep you more stationary. You could still roll and flail like kind of what we saw here.
Right.
It's much more difficult though. It's going to be harder for you to run away, for example. It's going to be harder for you to punch me or kick me or rush me, for example. So high risk handcuffing or prone handcuff or non-compliant handcuffing almost always goes to the ground.
Okay, and let's take it one step further. Is there anything inappropriate with restraining somebody who's on the ground and handcuffed in a prone position?
Can you say it again?
Yeah, is there anything wrong with restraining somebody who's handcuffed in a prone position, if it's required?
If it's required, I mean, if it's not, obviously there would be. But if they're not under control, then yeah, you'd have to control them.
Okay. You testified earlier about Graham versus Connor, and that's a civil standard, isn't it?
Correct. Graham versus Connor was a civil lawsuit, but the
Yes.
principles that came from that inform law enforcement training.
All right, objective reasonableness.
That's
from
one.
the viewpoint of the officer, is that right?
Correct.
What about the criminal standard here? What is that?
The criminal standard that will be statutory.
Yes, Your Honor.
Honor, it's ER 704. And Graham versus Connor was mentioned. It's not the same manslaughter statute.
It's calling for a legal conclusion, Your Honor.
Well, I don't know reference to the Graham case isn't if it's not a reference to a legal conclusion.
Right.
But having said that, I think we're approaching the limits here of where you can go with your expert testimony.
Maybe I can ask it this way, Your Honor. If Officer Rankin was restraining Mr. Ellis, as you've seen in his statement, as he was restraining, as he mentioned and described, would there be a substantial risk? Would he be encountering a substantial risk that Mr. Ellis would die as a result of that restraint?
No.
It's also outside the
Well,
knowledge.
let's
It's a medical.
let's excuse the jury and have this conversation. Ladies and gentlemen, please excuse us. Please do not discuss the case. Let's have this outside the presence of Mr. Nielsen. Well, here's my understanding of your question. Would someone in Officer Rankine's position be aware of a substantial risk that death may occur?
And then,
That's kind of the jury's decision, isn't it?
well, Your Honor, as the court will recall earlier, I objected in terms of statements like necessary and reasonable and conclusions on the use of force with an expert. And then Graham versus Connor being gotten into at length by the prosecution, and that's a civil standard. We're dealing with a criminal standard of manslaughter, and what I would have asked him further would be basically, I mean, it's easier to just ask the standard, which is there a substantial risk that someone's going to die if you do something, but you do it anyway? I mean, that's really what it is. But the question is, based upon what Officer Rankin knew at the time, as he came into the tail end of this incident, was there a substantial risk? Did he know there was a substantial risk that Mr. Ellis would die if he went ahead and restrained him? And the answer is no. I mean, obviously, in our minds. But I think that given that
Right.
Graham versus Connor was gotten into, and in fact incorrectly stated by Mr. Ryan, that standard saying it's just objective, and we know it's also subjective, with the 20/20 hindsight language, et cetera, that we should be entitled to inquire as to what the actual statute is in this case.
Ms.
Your Honor,
Nicolava?
again, this line of questioning invades the province of the jury, and they have been allowed to inquire into the actual statute for necessary and the Graham factors as they relate to the policy for TPD. But to go into medical terminology and decision to also, I mean, the question for the jury is whether or not there's a substantial likelihood. And Mr. Nielsen has no idea, because he wasn't there for the training of any of these officers. He has no idea what Mr. Rankin's thought process was at the time.
I don't know if any other defense counsel have cared to comment. Okay, I really think this goes too far. We've had discussions back when we were doing motions in limine and about following training and not following training and what's the standard in a civil case versus a criminal case and so on. There was an issue at some point where, I said, well, if they followed their training, it tends to show a lack of malice on the part of the defendants. And Ms. Nicolava said, the state doesn't have to prove malice. And I said, well, I didn't mean malice in some kind of legal sense. I meant in the sense of that they were, showed some kind of improper intent towards the defendant. Everybody here sort of said that there's a couple of things here that are kind of at conflict with each other. One, that until someone like Mr. Ellis, there's somebody the police are intending to arrest, are completely in control, they can't do anything about his medical condition. That's been one thing that's been talked about here. On the other hand, there's been also a theme here that says when the suspects are dealing with somebody, they need to control their use of force and otherwise monitor the suspect to see whether or not he's in need of medical care. And those things can be kind of overlapping to some extent. Now, the officer, in order to be guilty of a manslaughter, would have to be aware of a substantial risk that a death will occur or may occur. And, but that has to do with the totality of those circumstances. And I don't think that an expert witness, such as Mr. Nielsen, can properly be asked to opine on precisely that. He can point out that at any point in time, Officer Rankine's conduct was consistent or inconsistent with use of force rules. But even if someone was not in compliance with use of force rules, like for instance, let's say somebody tased somebody and they shouldn't have, but that conduct didn't produce the person's death. Well, they're not responsible for their death then, are they? Even if they've done something wrong. If they died for some other reason. So there's a limit to how much this use of force business matters. It isn't definitively determinative of the answer here, whether it was complied with or not. But you're asking to go a little farther than that, which is, in that position, would an officer like Officer Rankine be aware of a substantial risk that death might occur or may occur? I think that we can't reasonably ask Mr. Nielsen that question.
All right.
So I sustain the objection.
Thank you.
All right, let's have the jury back. We got 10 more minutes, and let's have Mr. Nielsen back. Thank you, Mr. Purzer.
Do you have enough water up there?
I do, thank you.
And when we're done with the session tonight, I want to talk to council just briefly about a scheduling issue. And the issue has to do with whether or not you are all available to be here on Friday afternoon. Not for trial, but for a discussion about jury instructions. Yeah, afternoon.
Judge, can I run outside the courtroom, let the next witness know that they can speak?
Sure. Okay, welcome back, everybody. Please be seated. The objection is sustained. New question.
You were just asked about whether or not you put anything in your report about Officer Rankin and Officer Ford. Did you do that? Did you have information in your report about them?
I don't, on a factual basis, but I didn't opine on his conduct.
So you have pages 19 through 21, I think, talking about what they said happened. Is that right?
Correct.
You have the opinion that Officer Rankin did not use excessive force. Is that right?
That's correct.
Can you tell the jury why you hold that opinion?
The level of force that Officer Rankin used, again, was a relatively low level of force. And when you talk about, like in terms of like lethal force, right, in measuring the likelihood of death or serious bodily injury, placing someone in the prone position and putting transient weight on their back, there's a very low likelihood of a bad outcome. They do happen, but it's a very low likelihood of a bad outcome. And we see that, again, as a police trainee, you're on the receiving end of that type of conduct daily. You know, through at the police academy, you're being prone handcuffed all the time with people kneeling on your back, and there isn't a rash of police recruits suffering catastrophic injuries because of that event. And even as a practical matter, you prone handcuff people all the time as a police officer. And these events happen, but they're very, very rare.
Can you give the jury any examples in sports of restraint where people are unharmed?
Objection, Your Honor. Relevance?
I'm sorry, could you repeat the question? I'm not sure I understand.
Ask if you could give any examples in sports of people that are restrained and are come out unharmed.
Sure. Overruled.
I mean, there are countless. If you spend a Saturday afternoon watching college football, you'll see 300-pound men stacked upon 200-pound men over and over and over again, right? Watch any MMA or a similar type of event, right, where people are deliberately placing weight on other people's back as much as they can over and over and over again. Any kind of collegiate wrestling, right? Like I said, I've wrestled for many, many years, and you know, I weigh 215 pounds, and I wrestle other 215-pound people, and not only do I deliberately try to put as much weight on that person in sport, right, without a catastrophic outcome, they do the same to me, and I'm here to tell you about it. And so, like I said, when we use force, you're always trained to understand that there could be things that go wrong with the force, and you're trained to react appropriately. But that doesn't preclude you from using that type of force.
Thank you.
And that's a very important, I think, principle when you're talking about force events and analyzing police use of force, is that all uses of force have the potential for injury, but that doesn't foreclose the option for that particular use of force. It must be judged on reasonableness, right, which is contextual.
And we talked about the continuum of force, ladder of force. Where would this restraint employed by Officer Rankin fall?
It would be on toward the lower end of force.
Would it even be considered a use of force?
And this is where, when you look at policies, it might depend. Some policies say, like, for example, when you use force, typically your department requires you to document that force, right? But at the low levels of force, there's a broad consensus about what should be documented, but sometimes injury or complaints of pain might trigger a documenting event. But absent that trigger, this, like just putting someone on the ground and handcuffing them by itself, if you just isolate it to that, that may not even be reportable under some policies.
As a use of force?
Correct. In contemporary, we would err on the side of
Sure.
documenting that, but I mean that's not a strong use of force.
Now, you reviewed I'm not going to go through the exhibits because it's almost the end of the day, but 898, from the time that Officer Rankin and Ford arrived until the time Sergeant Lim got there, how long did that take?
I want to say it was less than a minute. It wasn't very
Let
long.
me just put the exhibit up, 898. Thanks. Okay, we've got it here. Is that about 26 seconds from when Rankin and Ford arrived and then when the sergeant got there?
Correct. According to this, correct.
Now, the role of the sergeant is what at a scene?
At a scene, they're typically the ranking officer on the scene, and the personnel will have freedom of. They basically vet the decisions being made. If they disagree with the decisions being made, or if they want a particular decision to be made, they'll make it.
And do they have a duty to intervene in any way?
Not only the sergeant, but everybody there does.
That's my next question. There were a number of other officers that got there throughout this time period we see on the exhibit and beyond. Is that right?
Yeah, 10 or so.
Would they all have a duty to intervene if they saw something that they thought was inappropriate?
Yes,
And then Sergeant Lim, when he got there, he's the one that called for fire, isn't that right?
I believe so.
Did Officer Rankin have any duty to call for fire?
I think. I mean,
If Sergeant Lim was making the call to fire, did Officer Rankin have an independent requirement to call fire?
No, I think if fire is summoned, that's the paramount concern. And so it wouldn't really. I mean, oftentimes what you'll see, sometimes that happens where you just might not be aware they've been called, so you might have multiple requests. But in a situation where fire has been summoned to the scene, that's been handled, and it's been handled by your superior.
So going back to when Officer Rankin and his partner, Officer Ford, got to the scene, first of all, was this a priority call that they were responding to?
Very much so.
And we heard about mic clicks. What is the importance of mic clicks in terms of an officer's response?
Yeah, that can be inadvertent, and sometimes you bump your mic,
Sure.
And that happens from time to time. But if it's a series of mic clicks, that, 1, 2, that happens, 3, 4, 5, and then dispatch will start to try to hail the officer. And like for me, I'd be 6 Robert 1 if it were my call sign. They'd say 6 Robert 1, do you have traffic? 6 Robert 1, what's your status? And then 6 Robert 1, what's your status? And then they would close the air, which means that there's no radio traffic until we figure out what the heck's going on with 6 Robert 1, right? And they would keep doing that, 6 Robert 1, and then almost automatically officers would start heading that way, because that's a pretty frightening event, especially repeated mic clicks. That's almost always the sign of a fight happening.
And that's what happened here.
Yeah.
How important is officer safety in law enforcement?
I mean, it's among the most important considerations.
What's more important?
Like your guiding principle is you have to come home, right?
And so what kind of priority does a call like this have with respect to officer safety?
yeah, no matter what you're doing, you would stop what you're doing and you would go to that event.
So then that's what Officer Ford and Officer Rankin did, is that right?
It's my understanding.
And what did they encounter when they got there to the scene?
My understanding was that they found Mr. Ellis in the prone position with Officer Burbank and Officer Collins, kind of gassed out, winded, still kind of in his vicinity. My understanding was that there was a loaded pistol magazine, like scattered on the street.
Why was that of concern?
If you're just going into that cold without any context of what's happening, and you saw that would, like, you know who that belongs to, and you would have to on some level account for the fact that that might not be the police officer's equipment, right? And you would proceed with that as a consideration until you were, I think, disproven. And so you don't know if it came out during the event, or if that was somehow associated with a person being detained.
What else did they encounter?
Can you be more specific?
Well, let me ask you this: with respect to the magazine, had anyone been able to pat down Mr. Ellis at that point?
Well, my understanding is they didn't know, and even if you didn't know, you would probably still try that anyway. Like, you wouldn't err on the side of that not happening.
And under your understanding of Terry versus Ohio, you can basically pat someone down on less than probable cause. Is that right?
Correct.
Okay, is that patting someone down for weapons?
Correct. Yeah, a weapons frisk.
When did that happen in connection with Ford and Rankin's arrival at the scene?
My
Do you know?
my understanding was that Rankin was the first person to do that.
So Burbank and Collins weren't able to do that.
I don't think that they were.
You know, I don't know if we want to stop now. I've got a little bit more to go.
We'll stop. It's after 4. Okay. Ladies and gentlemen, please do not discuss case among yourselves or anyone else. Please do not look at any media or social media on the subject of this trial. Thank you very much. And we'll see you tomorrow morning.